Thanks, Ryan, and happy to catch up with you today. Myself, and this will probably go to some of the things we talk about. I'm an attorney now, but I wasn't always an attorney. And it wasn't my goal when I grew up to be an attorney or anything like that. I actually only went to law school because I was frustrated by attorneys, and it kind of influences how we do things today. I launched my first company right out of undergrad, and I was helping a college roommate with a product that didn't exist. And as we created that, we ended up creating a company. It was going amazing, but kept having frustrating experiences with legal, where my attorneys would tell me one thing or they would take me down a certain path, and it just didn't make any sense for the business. You know, they were correct in telling me what the law said, but not how it applied to me. And tons of stories I could tell you about it, but the straw that broke the camel's back, I got a $14,000 bill for a $12,000 fight. My spend on legal had actually exceeded the total amount in controversy. And the fight wasn't even done yet. And I just said, wait, stop. You know, why on God's green earth would I pay more than this whole fight is even worth? There's got to be another way. I'm not going to do this. So I signed up for law school. I went to law school by night while I was running the DME company, the durable medical equipment company, by day. And I watched these two worlds collide together, how business and law could actually work together, how the legal knowledge could actually empower and inform the business decisions instead of be a part of this frustrating cycle that I had been on. And it was kind of funny because when I went to law school, it was so that I could just add in-house counsel to my title as president and COO of our DME company. And I thought I'd be done hiring attorneys. But joke's on me, now I employ 23 attorneys because we have Immix. So fast forward to, I had such a blast in law school. I found this application together, started practicing when I got done. I went into big law for 4 years, but then founded Immix shortly thereafter. So we founded Immix in 2011. It was to be the law firm that we had always wanted as business owners. And that goes to our ethos, it goes to our culture. Our attorneys actually know what it's like to be the client. Our attorneys have grown up in family business. They have launched their own business like I've had. They've been in business, but they've been the client. And it does inform how we go about things. Happy to touch on examples if you like, but that really is the why behind what we're doing.
All right. So, initial follow-up question. Did you win, that $12,000, $14,000, dispute, where you got that bill? Did you continue to drag it out after that?
No, settled it on the spot. Said, this is ridiculous. We shouldn't even be fighting about this. And my opponent agreed. We shouldn't be fighting about this. It was absolutely ridiculous for us to be in that dispute. Time zone. We're in other markets where we just haven't needed to have a physical office. We don't have attorneys that want to show up to a physical office. It was interesting, even last week for our M&A practice, we closed 4 transactions. 2 of them were in Washington, but 2 of them were in Texas because we have some influence in Texas and in that market there. And so we're largely following where clients need us. I'm sitting in Nashville, Tennessee right now. It's been a really fun market to serve. But like I mentioned, Pacific Northwest is where our offices are and still where a lot of our deals are happening. And so M&A is the group that I lead, but we do want to serve closely held businesses. So we've got employment, we've got intellectual property, we have commercial litigation, basically all the things that a business will need. We've got those different specialties in-house. Encourage people to seek out is an attorney that has experience in M&A. Think of it as like healthcare, where you wouldn't go to a heart surgeon to learn about your brain. There are such different areas of the law that it's important to work with someone who actually knows how to run a transaction. And unfortunately, a lot of people learn about that the hard way. They will have never really needed legal in the trajectory of their business, for example, or they've had a great real estate attorney or a great transactional attorney, but not someone who's ever done M&A, or even someone who's done M&A in real estate, but not in the gaming space, for example, which has its own nuances. And so seek out experience first. And then with experience as table stakes, then look for someone where you've got a personality fit. This is someone you're going to spend time with. This is someone that you're going to want to not be scared to call, or not feel like you don't have a good connection with, or if you feel like you're getting explanations that's a terrible situation. You want to make sure you've got a good person-to-person connection. Really important transaction. And again, this is going to be someone you're going to be spending time with. So make sure it is someone where you feel a good fit. Number one for me, as it relates to the core document for the deal, is to make sure it's right sized to the deal. Not all purchase and sale agreements fit all situations. I mean, and we do a lot of transactions. We do more than 100 transactions a year, every year, and we do them of all sizes. I had a fun moment a few months ago where we'll have several days where there's multiple closes in a day, but I had the biggest delta of my professional career in a single day, where we closed one deal that was 65 grand all in, tiny little wine bar that was trading hands. In the same day, we closed a GovTech deal for $143 million. So to have that big of a delta between transaction size in the same day really speaks to this approach of make sure it's right sized. You better believe the purchase agreement for the wine bar deal was not the same as the purchase agreement for the GovTech deal. And I do watch people, either accidentally or just not knowing, that they trip into thinking that one purchase agreement is good for any deal. And it's always kind of a warning. Back to a moment ago when I want you to be with an M&A attorney instead of just an attorney. When we have a tiny little deal, but we see a 120-page purchase and sale agreement come across, it's like, wait, time out. Do you actually do these transactions, or are you used to these transactions? Because that is completely and totally over-lawyered. Instead, let's figure out what you actually cover in this deal. Because if your spend is bigger than the transaction, terrible result. I'll give you two that jump immediately to mind. One is kind of similar to the last point, which is when people fight about things that don't actually matter. And part of the ethos of our firm, back to having business experience, we don't want to fight about things that don't matter. I'll be in transactions where people are just going nuts over the reps and warrants of a deal. It is an important section. It's important to understand what's there. But if you're in a transaction where there's protection from breaches of reps and warrants, and in this particular deal that comes to mind for me, we were triple insured. There was reps and warrants insurance, there was a holdback, there was an escrow. So 3 ways in that if there's a breach of the reps and warrants, there is recourse for it. And opposing counsel wanted to fight about reps and warrants. I said, wait, time out. What are we doing? Why does it matter? This thing is even over-insured, in my opinion. So I do see the mistake of people don't take the step back and think through what is the application of what we're talking about. And if it doesn't actually matter, let's move on to the next thing. And then I think the other one that really jumps to mind, and it is so important, especially on sell side, but even on buy side transactions, I find myself needing to check and make sure that the conversation has happened. And that is that the seller has prepared for what it's going to feel like to no longer own the business. And I'll give you an example of probably the worst time that I saw this play out, where we were on buy side of the transaction. Sell side of the transaction had not thought through what they were going to do on Monday. We had a Friday closing. They hadn't thought through what does it look like on Monday when I no longer own the business. And I'm going to date myself a little bit with this, but this was an old-fashioned in-person close. We were all coming together to sign on the dotted line. And my client was there as buy side. We were very excited. We negotiated this deal. It was a pretty sizable transaction for a company that had been around for more than a century and kind of an iconic brand, and lots of excitement going into it. We go into the closing room and the seller walks in without his attorney and looks very uncomfortable, but he says, I need to ask a question and my attorney won't ask it for me. And we said, whoa, time out. Represented party, there's ethical considerations we had to go through in that moment, but he was able to ask the question of my client directly. And his question was, can I come to work on Monday? And this was not a deal where we were bringing in, where there was a consulting role or an advisor role. There was no earnout. This had been a largely passive at least a decade. So it wasn't that he was needed to run the company. It was that his identity was wrapped up in going to this place of work and in showing up there every day. And he hadn't thought through, what is it going to look like to not come to work on Monday? And it was a disaster. My client very politely had to tell him, well, no, you don't get to come to work on Monday. I need to run this company. I'm going to kind of take it in a different direction. I'm going to be implementing changes. I can't have the team reporting back to you instead of reporting to me. And so he actually pulled the plug on the deal. We were there that day to sign, and the deal didn't go because there had been no work done beforehand for the seller on what this was going to look like. Varies on type of transaction, whether or not there's real estate involved. That's usually a big driver. Find whether or not there's escrow title or anything like that. I think the more consistent thing I see is whether or not there's a broker in the transaction. And so just walking clients through, transactions that really shouldn't be the broker, how the broker can add to the process with creating the market, even when the parties have been identified, keeping the trains moving, keeping everything going, help with the legwork that goes into closing a transaction. Because other deals come up, there is no broker in the transaction. And we find in deals we do, we get parachuted in sometimes at the 11th hour by a broker because it's a busted deal or the firm that was there before for some reason. Or we get brought to the table because a client will get an unsolicited offer and just say, please help me go. I want to close this deal. And so we find in our practice, it's about 50-50 of whether or not there's a broker involved. But we love walking clients through the role of a broker in a transaction and thinking about whether or not they should proactively reach out for one and get one involved. First, I just try to really seek out what the problem is, find out who are all the parties in the transaction, who are the professional advisors on both sides, and try to get a sense for their view and how they approach transactions. I'll tell you the number one way I see a deal not going well is when it's just taking too long. People like to say that time will kill all deals. I have seen that in practice. It really does hurt a transaction when they stretch too long in so many ways. And a lot of time, there can be a lot of reasons for it, but so commonly, one of the reasons that a transaction will stretch is because of how opposing counsel views their role in the transaction. And so now and then I'll need to just call it out for the group. First, I'll try to reach out to that person directly, we can connect, see if we can get on the same page. If not, sometimes it's in a group negotiation. I'll never forget one. It was a very effective conversation, thankfully. But we had been in a transaction that was just dragging on for no good reason. And we were in a group negotiation, trying to hammer through it, not getting very far. And I said, wait, opposing counsel, what is your job? And he said, protect my client. I said, nope, that's not it. I appreciate that. And that's important. You need to protect your client. But ask your client what your job is. And he asked his client, and the client said, to close the deal. And I asked my client, what's my job? And he said, to close the deal. I said, okay, let's briefly. How can we look at this differently, knowing that our marching orders are to close the deal? I've never seen a deal without hair. There's plenty of ways you can protect against it. You always want to make sure both sides of the transaction are very well advised on where the liabilities live, how can they ensure the liabilities protect against them. We always want people to be eyes wide open. But if the approach is to not close the deal, then you might be doing a disservice to your client. Now, to be clear, if the marching orders from the client are not to close the deal, like if they're just kicking the tires, they want to go maybe, maybe not, it's a different engagement. So many times, especially when a deal's been going forever and just won't close, I find it's that lack of mentality, or we just need a mentality shift. What's our job? Close the deal.
Okay, well said. Any other warning signs for sell-side business owners?
Yeah, there's one in particular that I think is so very important. I will have sell-side business owners that are, of course, incredibly busy. They need to be running their companies while also doing a transaction, which I'll even just sidestep for the moment to say, so very important that they continue to run their businesses. So many times people will get so drawn into the transaction and they'll forget to run their business, or they'll neglect to run their business. And that can have catastrophic results. So I always tell my sell-side clients, first, run the business. Second, we'll figure out where to fit in this transactional work. But for the ones that are already doing that correctly, they'll a lot of times just want to say, okay, I trust you to do you part. I'll run the company. However, I really do need their help. And there's one area of the agreement in particular where I don't know everything about their business, and that's the representations and warranties. That can be, especially in larger transactions, several pages of a lot of legalese, and it sucks to read. And so I'll tell them, what's your happy place for reading where you can be on point and really pay attention, but you need to read this stuff because we then need to disclose against it. So if anything's not 100% accurate, we then disclose against it, because if we don't, they're in breach right when they do the deal. What a disaster. But I've had situations where through Q&A, it becomes apparent the client has not read the reps and warrants. And so I'll need to either step back, set a time where we read them together gracious. You usually don't want to use my time like that, but every now and then it has to be done. But I just always give that warning saying, please read these. Because again, if they're not 100% accurate, you're in breach. But we can also disclose against that, and we can edit them, we can negotiate them. So without having taken the time to walk through them, liability, take the time to walk through them, we can mitigate the liability. So I know it's a painful part of any agreement to read, but it needs to be done.